Okay, we are recording. Well, good afternoon, everyone, and welcome to our program. Our program, which is the LGBTQ issues in the unionized workforce. This program is what I consider a dual program because it involves both employers and unions, ensuring the rights of employees and equality for employees that are the members of the union. Just a little bit of housekeeping. As you see, there might be a chat button on the bottom of your screen. Please hold your questions until our presenters finish. As you come up with your questions, please type them in, and then when we are finished, we'll address them. If in fact we don't have enough time to address all the questions, I will put on two email addresses, the New Jersey email address and Barbara Diamond's email address, and you can forward the questions there. Thank you. We do have three panelists today. I'm going to introduce them briefly. Jonathan Cohen. Jonathan, wave. Thank you. Jonathan is a management attorney. He's the founder of Plosia Cohen, along with Jamie Plosia, his partner. Jonathan has done a lot of successful claims, I want to say, in the New Jersey courts, the federal courts, as well as other agency. Jonathan himself is the president of the New Jersey chapter of LERA, and he's also being awarded the fellow, 2020 fellow for National LERA. As you know and can see, Jonathan is from and works in New Jersey. Bill Dwyer is, Bill wave, okay. Bill is our faculty instructor at Rutgers University. Bill is also from New Jersey. Bill practices in labor relations. He instructs in labor relations. He does research in labor relations, and he focuses mostly on contract negotiations and conflict resolution. Bill brings to the table over 25 years as a labor manager in labor relations in one of our big corporations in the country, which is known as public service, gas and electric. Barbara Diamond is an attorney over 30 years. She does hail from New York, but she is living in Oregon. So we're getting our two parts of the country pulled together today. Barbara has worked for 30 years as an attorney for the civil rights and labor relations areas. She also is the founder of Diamond Training, where she does train in the area of, I want to make this sure I say this right, she does in anti-bias divisions of organizations. She can be reached at her email that I will put up later on. I am your moderator and co-host, Lucille Alfano. I am a labor arbitrator and civil mediator. I bring to this program my background of 20 years as a union president in a New Jersey-based public school system. Yes, I am too from New Jersey. And with that, I would like to remind everyone to stay muted during the presentation, and I will turn it over now to Jonathan, who's going to give us our foundation. Jonathan? Thank you, Lucille. When Lucille says that I'm going to give you the foundation, my intention is to give you a little bit of a legal framework with regard to LGBTQ issues in the workplace. Obviously, in 15 minutes, I can't do all of that, but I'm going to try to give you a bit of an overview. In my lifetime, LGBTQ, I think, is the modern civil rights movement. Although we've seen from recent events, that doesn't mean that there aren't ongoing other civil rights concerns and other civil rights movements. But really, even during the course of my professional career, as well as the course of my lifetime, there have been seismic shifts in terms of public perception, as well as the law
when it comes to the protection of LGBTQ community in the workplace. Unfortunately, what we've seen in the civil rights movement previously, and Bill Dwyer may touch on this a little bit going into today, not always is society up to speed, and that's the reason why we have civil rights movements. And frequently, the courts are the places, along with, and even before state legislatures, the U.S. Congress, the executive branch, et cetera, we find in courts relief or interpretations of laws that will benefit and protect marginalized populations. And that has been the case traditionally. I'll say very briefly, there's a long history of struggle, obviously, to bring the analogy into the civil rights movements for African Americans, not just against management, but unions also. One of the points I want to make today is, although unions we perceive to be progressive, they're not always at the forefront of the civil rights movements. Usually, we've seen historically is that labor unions, with some exceptions, move at about the speed of society, maybe a little bit faster, but not a ton faster. To give you an example of that, there were a whole lot of cases from the 1950s, 60s, and 70s where African Americans had to sue their unions in court in order to obtain equal rights. One such case, perhaps one of the most important of them, is Franks versus Bowman Transportation Company. That was a U.S. Supreme Court case from 1976. It was in that case that the U.S. Supreme Court said that Title VII of Act of 1974 is a powerful enough law to not only redress grievances of applicants in that case for jobs who were denied jobs from the union and an employer with respect to because of their race, but also retroactive seniority could be granted. So that was a case where basically the U.S. Supreme Court said, look, Title VII is a very powerful law. You can use it for race, gender, or race, sex rather, and other religion, other categories. And if in fact it's proven that there could be a violation, courts have very broad remedial powers in terms of fashioning a remedy. Prior to recent times, as I said, society has taken a long time to come to grips with the protections that should be afforded to LGBTQ in the workplace. And that's been reflected if you look at the history of court decisions. One case in New Jersey that I cite to anecdotally was a case involving education law here in this state. The name of the case was Henry Goodwin, I believe. And in that particular case, there was a teacher, actually it was Henry Grossman, I apologize. It was actually from the Intermediate Appellate Court in New Jersey. And I'm shocked when I read this because the case is from 1974. It's the Intermediate Appellate Court in New Jersey, meaning it can issue published decisions. This case is a published decision. Unless it gets reversed by the New Jersey Supreme Court, which is rare, it's technically a controlling decision. And that case found that the Commissioner of Education was correct in finding that someone who was assigned male at birth and transitioned to female, when that person tried to return back to school, that she was, quote unquote, incapacitated. That's the language that was used by the court to teach children because of the potential psychological harm that would be caused to her 4th, 5th, and 6th grade students. What's the psychological harm? Well, according to the court, it's because we thought this teacher was a male and now she presents as a female. So obviously that case is disturbing. I don't think it would stand up today, but it looks like it's still good law, but it shows you where we were at a couple decades ago. In the time since then, I would say really the 2007 about is when you start seeing major changes in state law to protect LGBTQ. And when I say that, I want to break it up into 2 types of protection that we want to look for in these laws. Number 1 would be sexual orientation. Number 2 would be gender identity. As it presently stands, there are 22 states plus the District of Columbia, which do have laws protecting employees from discrimination in the workplace due to sexual orientation and gender identity, meaning both. There's Wisconsin, which actually only protects on the basis of sexual orientation, but doesn't say anything about gender identity. That leaves 27 states that have no explicit statewide protections for employees due to gender identity or sexual orientation. And the only way that employees in those states may have any right for protection is if their locality, whether it's their city, the county, something like that, has enacted a local ordinance. That is somewhat common in these states. If you look at the cities, just to give one example, I looked at the state of Texas. There are laws in most of the major cities in Texas, if not all of them: Houston, Dallas, Austin, San Antonio, which generally protect gender identity and sexual orientation as categories that you can't discriminate against in employment. Although in some cases, when you look across the country and you look at these local laws, they might only protect government workers or something like that. Not all of them are necessarily universal and protect private workers in private employment as well as government workers. So just to talk about some states that are important to us. Every state is important to us, but Oregon is where we are virtually, so I thought it was worth talking about. Like I said, 2007 is kind of where we see this wave. 2007 is when the Oregon Equality Act was passed. I think it became effective January of 2008. Governor Ted Kulongowski, if I pronounced that right, Barbara, I know that, okay, good, I got that right, was the governor who signed it into law. If I'm not mistaken, in my research, I think it was presented to him not him personally, but it was presented to governors something like 33 times before it was finally signed into law. So it was a long effort to get that law passed. It's similar to in New Jersey. In 2007, we've had a long-standing law, which basically just put every category in. That's the New Jersey Law Against Discrimination. It was around 2007, around the same time that law was amended to also add sexual orientation and gender identity as protected categories. They may have already been protected under the general heading of sex or gender, but this made it very clear that they're entirely protected. Question is, what about federal law? Because you still have 27 states, like I said, where you don't have any state protection. And that becomes interesting when it comes to Title VII. As I alluded to earlier, Title VII is the law that any employer in the country would have to meet if they have at least 15 employees. It was passed in 1964. It says it protects you on race, color, national origin, sex, and religion. Well, the big issue is, what does the word sex mean in terms of who does it protect? Does sex include gender identity and sexual orientation, or does it just mean you can't discriminate against me because I present as a binary female, and therefore you can't discriminate against me based on sex stereotypes and the like? And that's a split that we'll go into, which is a very hot topic right now. One case that sort of made it tough on these circuits, I think, that are finding that gender identity and sexual orientation are not covered under Title VII was Price Waterhouse versus Hopkins, involving obviously one of the huge accounting firms. In that case, it was a assigned female at birth employee who was, by all accounts, not saying that she had any gender identity or sexual orientation claims. It was just that she wasn't perceived by her male counterparts to conform to the sex stereotype, so to speak, of how a female should act in the workplace. One partner described her as quote unquote macho. Others said, well, foul language is okay, but not from a lady. So when she was denied partnership, she sued. And what the US Supreme Court said in that case from 1988 was, well, you know what? We think a woman should be able to bring a case if she's been stereotyped based on her sex and she's discriminated against on that basis because she doesn't meet stereotype. And what I believe, reading the cases since then is, well, that put circuits that don't want to give, meaning the federal circuit courts that don't want to give gender identity or sexual orientation protection under Title VII, a hard line to draw, because they're saying that you can't discriminate for sex stereotyping, meaning that you're not acting at these perceived norms that society has imputed to, the binary. But however, if you are actually saying gender identity or sexual orientation, we're going to cut a big box around you, say you're not protected under the law, and good luck, doing something else. Cases where that actually happened, the employees had no recourse but to sue the union and the employer. The two cases I'll cite are both union cases. Probably the majority of cases out there don't include unions, but because of our topic, I'll mention them. There was a case before the Second Circuit changed its analysis of Title VII, Folks versus Iron Workers Local 40, not that long ago, 2015. That case, we have a plaintiff who's assigned female at birth and identified as male, and he was discriminated against and lost jobs from the hiring hall after he received comments such as, "I always thought that you'd be a girl that would work and make the man happy," because he sued the union. Again, the Second Circuit said, you know what, sorry, no luck for you under Title VII, but you can sue the union and you can sue the employer under Title VII, under the National Labor Relations Act and duty of fair representation. In that case, like I said, I'm not attacking unions, just pointing out this blue collar union, the Iron Workers Local, was not exactly what you'd put on a pedestal as your vanguard for how to be inclusive, right? With the way that they treated this employee. Similarly, Gilbert versus Country Music Association, the plaintiff in that case was a gay man who was denied opportunities. He was actually threatened by a fellow union member, according to his allegations, saying that the fellow union member will stab him because he's a quote unquote faggot. In fact, that wasn't a hollow threat because it appears that individual there were facts that indicate that individual had stabbed other gay men in Atlanta. The plaintiff complained about that, and the Sixth Circuit found, sorry, you're out of luck under Title VII. Maybe you can bring a claim against your union and your employer under the National Labor Relations Act, but no luck under Title VII. He was denied the opportunity to do some of the main jobs that made him money, such as the Country Music Awards, which many of us may be familiar with. And one of those cases also illustrate is if you're going to be the plaintiff's lawyer in one of these circuits that doesn't recognize Title VII, you've got to basically make a case for sex stereotyping under the Price Waterhouse, rather than actually saying what it's really about, because otherwise you're going to get booted from court. And then the court starts saying, well, you're just conclusory setting up things, saying, oh, well, he didn't conform to stereotypes because he did X, Y, and Z, or she didn't, whatever the case may be, which is really putting plaintiffs' attorneys in an untenable position where they're trying to fill their complaint to meet this 1988 standard instead of saying what it's really about. The EEOC, since the Obama administration, has taken the position that Title VII should be inclusive and protect the term sex should include sexual orientation and gender. Since Donald Trump has come into office and power has shifted, the Department of Justice has done a 180 on that and said, no, hey, EEOC, come on here. That's not what we believe. We believe that we agree with the circuits that say that sex only means sex and doesn't include sexual orientation and gender identity. There are presently 3 cases that are up before the U.S. Supreme Court. The first one started from an EEOC action. That's in the Sixth Circuit, EEOC versus RG and GR Harris Funeral Homes. In that case, the Sixth Circuit did side with a transgendered employee who was assigned male at birth and transitioned to female, who was terminated after the employee learned of her transition. There was also a dress code policy issue, which you might hear about a little bit later. Another case, like I said, the Second Circuit did an about face and is now finding that, along with the EEOC, that there is protection for gender identity and sexual orientation. That case that's also before the U.S. Supreme Court as part of this triumvirate is Zarda versus Altitude Express. Facts of that case: gay man was a skydiving instructor. He was fired after a female client reported him for telling her his sexuality. What he said is that he frequently, when he would go skydiving with females, because they were so close together, he would say to them, I'm gay or whatever, so I hope that you're not uncomfortable. I'm not trying to grab you. We just need to be close for this. Went over well with most people. This woman complained. He ends up getting fired. Second Circuit says that's no good. You're protected under Title VII. And the third case, which came out the other way, is Bostock versus Clayton Board of Commissioners. That's in the 11th Circuit. A gay man who was working as child welfare services coordinator, always received positive reviews, had a strong work record. All of a sudden, he joins a gay recreational softball league. Next thing he knows, he starts getting written up, starts getting disciplined, contends that it's because of his sexual orientation, files a claim. The court says, you know, your sexual stereotype claims, which we would consider under Title VII, are just conclusory. So your lawyer just put that in there to try to give you a case. And, you know, you're really just trying to mask a sexual orientation case. We don't believe sexual orientation is part of Title VII. You're out of luck. Case dismissed. So these 3 cases are all going to the U.S. Supreme Court. Could be decided sometime this month. And when that happens, we'll get an answer as to whether Title VII is going to be construed as the law of the land to protect gender identity and sexual orientation, or whether it won't be. And then the 27 states will have a strong eye on them to look at on whether they're going to do something to protect these categories. So I thank you, and I look forward to the question and answer portion at the end.
Thank you, Jonathan. You can tell Jonathan is our litigator, and he is very much up on all the recent court cases. Should you have any questions for Jonathan, kindly put them in the chat room, and we will get to them at the end of this presentation. Our next presenter is Bill Dwyer. Bill Dwyer is our New Jersey LIRA liaison to LIRA National, so he has a lot of connections here. So Bill is going to take us through the journey from where Jonathan left us off into what has happened and what is happening organizationally in this particular titled program. Bill?
Thank you, Lucille, and welcome to our session, everyone. So, you know, a few months ago, Jonathan called me and he told me about this presentation that he'd be proposing for the conference. And he said he thought it would be a good idea to have an academic on the panel to present from that perspective. So he asked me if I'd be interested, and of course I agreed. And then I began to ask myself, what the hell does an academic perspective of the LGBTQ issues in the unionized workforce look like? Well, for better or worse, I guess you're about to find out. So I suppose I could have presented all kinds of statistical data derived from scholarly research, but I decided not to do that, or at least too much of that. And here's what I came up with. I thought I'd start out with a high-level overview, including a brief look at LGBTQ American labor history, some examples of joint initiatives between labor unions and the LGBTQ movement, some other forms of LGBTQ and labor alliance, and the status of pending labor legislation, specifically the Equality Act, which Jonathan just mentioned. Then I thought I'd take a few minutes to answer the question, what are the issues on the shop floor? Based on my experience in my first career, heading up labor and employment relations for a Fortune 250 in the utility industry. So let's get into this. While the labor movement in the United States has a long tradition and history of liberal economic objectives, what is less apparent and rarely discussed is the record of regressive non-economic policies. For example, this is a record that includes persistent racial and ethnic discrimination and the exclusion of minorities. One only needs to probe at the surface of the history of the American Federation of Labor to find a deep-seated racist philosophy centered on promoting the interests of whites. While Samuel Gompers, longtime president of the AFL, secured a place in history by successfully fighting to promote the interests of the working class, he was openly intolerant of minorities, most notably Black and Chinese Americans. This intolerance spread into various policies and practices of the American labor movement during the early and middle 20th century towards other groups that somehow deviated from the American dream model of the nuclear family, including those that did not fit the traditional heterosexual mold. So with that brief, very brief historical context, I'd like to now focus on the relationships that were slowly and eventually established between organized labor in the United States and the LGBTQ community. In many ways, the labor movement and the fight for LGBTQ rights evolved along very dissimilar lines with different goals and different objectives. The primary focus of the labor movement in the United States over the past century has been economic. That is, to organize as many workers as possible and to improve the material status of those workers. The fact that LGBTQ workers benefit materially by being members of unions is merely a consequence of membership. The LGBTQ movement, on the other hand, has established as its focus the quest for the civil rights already enjoyed by most of straight America. That is, freedom from discrimination based on sexual orientation or gender expression. Before the momentous 1969 Stonewall Rebellion, the American labor movement largely ignored issues facing the gay community. So Stonewall became a key turning point in terms of how society at large, and unions specifically, gradually began to understand the deplorable mistreatment suffered by members of the gay community. Stonewall also triggers the start of conversations about the civil rights of gays and lesbians. As the gay liberation movement gained momentum, organized labor gradually began to recognize that discrimination based on sexual orientation victimized union members, divided the ranks, and weakened union organizations. The American Federation of Teachers was the first union to recognize this, passing a resolution opposing discrimination based on sexual orientation, with the National Education Association following their lead in 1974. These breakthroughs kicked off a trend where labor unions, first in the private sector, and later in the 1980s in the public sector, gradually began to successfully negotiate contract provisions aimed at protecting LGBTQ rights in the workplace. In 1974, San Francisco's gay community partnered with the Teamsters to support a boycott against non-union Coors Brewing Company. This partnership broadened to a national boycott that forced Coors to discontinue its policy of discrimination against union supporters and against LGBTQ community members. Coors saw its market share plummet as a result of the boycott and eventually agreed to stop asking job applicants about their sexual preferences. Over the next 2 decades, support for the LGBTQ community grew in the labor movement. In 1979, for instance, the AFL-CIO openly expressed its support for gay rights by calling for federal legislation banning workplace discrimination based on sexual orientation. AFSCME adopted gay rights resolutions in 1982. In the 1980s and 1990s, LGBTQ caucuses and labor networks were founded in many labor unions as thousands of gay members organized to protect their rights. This momentum slowed in the early 1990s when the AFL-CIO failed to endorse marriage equality. In response, LGBTQ activists founded an organization named Pride at Work. After several years of pressure, the AFL-CIO officially backed marriage equality in 2005. 7 years later, the AFL-CIO supported legal action leading to the Supreme Court decision that recognizes same-sex marriage. In the wake of this victory, Pride at Work continues to mobilize union support for a broad range of LGBTQ rights. Pride at Work exists to build tolerance and support for LGBTQ members in the workplace and in labor unions. The organization educates LGBTQ people about their rights as workers. The organized labor movement and the principles of trade union solidarity. It encourages and assists LGBTQ workers to organize and to become active participants in the trade union movement. It opposes discrimination on the job and in unions based on sex, gender identity, gender expression, sexual orientation, race, national and ethnic origin, age, disability, religion, or political views. It encourages LGBTQ workers to register and vote to exercise their full rights and responsibilities of citizenship at the local, state, and national levels. And it educates the union movement and the public about the economic and social needs and interests of LGBTQ workers. Pride at Work also helps to educate union members on larger political questions of importance to the LGBTQ community, such as gender identity, anti-discrimination protections, and marriage equality. Nationally, Pride at Work led the struggle for domestic partnership benefits, an issue important to LGBTQ couples and non-married heterosexuals. Pride at Work has also recently undertaken an initiative to advocate for healthcare benefits for special needs of transgender workers. Next, I'd like to talk about the International Labor Organization's Pride Project. Well, the acronym PRIDE stands for Promoting Rights, Diversity, and Equality. This organization conducts research on discrimination against lesbian, gay, bisexual, and transgender workers across the world and highlights good practices that promote meaningful inclusion. PRIDE's research methodology is structured around the 4 pillars of the ILO's decent work agenda. Fundamental principles of rights at work, employment promotion, social protection, and social dialogue. With a 5th pillar devoted to assessing the particular challenges related to the interplay between HIV and AIDS and LGBTQ issues in the world of work. The next alliance is called, of all things, Sleep with the Right People. Sleep with the Right People, pretty clever name when you learn about the organization, is a collaboration between the labor union Unite Here and the LGBTQ community, working jointly to leverage their combined power to ensure that hotels respect their workers, specifically Unite Here union members. LGBTQ travelers spend over $60 billion every year on business and recreational travel, and major hotel chains spend millions of dollars annually on advertising that specifically targets the gay market. This coalition calls on members of the LGBTQ community to sleep with the right people by honoring picket lines, various hotels across North America, and whenever possible, patronizing union hotels when traveling. The basic premise is that the parties are stronger together rather than alone, and combating wealthy individuals and corporations who stand in the way of the LGBTQ community achieving full civil and economic equality. Over the course of the past 20 years, organizers in LGBTQ communities have built comprehensive alliances with labor activists to promote gay labor issues at national union conventions and at community-wide and regional campaigns. At the local union level, these gay labor collaborations initiated important innovations, including contractual protections against discrimination, domestic partner benefits, and AIDS education in the workplace. Along with these alliances, progress is being made on the legislative front. The Equality Act is a bill passed by the U.S. House of Representatives in May of 2019 that would amend the Civil Rights Act to prohibit discrimination on the basis of the sex, sexual orientation, gender identity, or pregnancy, childbirth, or related medical condition of an individual, as well as because of sex-based stereotypes. The Senate received the bill for consideration on May 20, 2019. The Equality Act is not a new concept. In fact, the original Equality Act was developed in 1974. At that time, the bill sought to amend the Civil Rights Act to include prohibitions on discrimination on the basis of sex, sexual orientation, and marital status in federally assisted programs, housing sales, rentals, financing, and corporate services. So I'd like to spend the last minute or two that I have focusing on some of the LGBTQ issues at the shop floor level. One of the factors that should be a concern for employers primarily is the fact that fear prevents LGBTQ employees from bringing their full selves to work. The Harvard Business Review recently published data indicating that over 40% of LGBTQ workers in the United States are closeted in the workplace, and nearly 2/3 of non-LGBTQ employees believe that it's unprofessional to discuss sexual orientation or gender identity in the workplace. LGBTQ people often cover or downplay aspects of their authentic selves, for example, by hiding personal relationships or changing the way they dress or speak in order to avoid harassment and discrimination. Well, I see that my 15 minutes of fame have run up. So at this point, I'm going to hand it back to Lucille.
Thank you, Bill. And now you see why Bill is such a great instructor at Rutgers University. Bill does this as well as not just with his classrooms, but also in seminars, teaching equality and how best to work out conflict resolution issues through negotiations, which we're going to hear from Barbara. This is a segue into Barbara now. Barbara, our next presenter, will be reviewing model language as well as how best to address these issues in the workforce, to address them on a professional, personal level, as well as to protect them as an equal employee contractually. Barbara?
Yes, thank you. I'm going to use a PowerPoint this morning. I just wanted to say hello and tell you that there are two different attachments or handouts that you might want to make sure you have. One is the PowerPoint that I'll be using today, and the other is a report out from the Queer Summit that was held about a year ago here in Portland, Oregon. I like to think of Portland, Oregon as a very welcoming and progressive city with respect to folks who are transgender and other queer folks. I identify as queer, and I use that word with great pride. So let's find the PowerPoint here. Okay. One of the things that we did at the Queer Summit last year was that a large number of Oregon national unions sent representatives from the LGBTQ leadership in their organizations, as well as members, to a full-day conference. And part of what we did in this full-day conference with folks from trade unions, of course the IBW, lots of entertainment industry folks, nurses, really a very cross-union attempt with folks from the LGBT community and allies, was that we spend some time brainstorming about what could be done in collective bargaining that might benefit LGBTQ members. The Queer Summit resulted in the creation of bargaining proposals, which also could be used as policy language. We have that set of policy collective bargaining agreement proposals available to you on a Google Doc that you can access. I'm hoping that people will add to it, change it, and use it widely, because it was the effort of many minds coming together, people with different identities, trans folks of color, trans folks who were not here with legal papers. We came together and said, well, what could unions do in the civil rights arena for our community that would improve our situation, rather than queer leaders focusing their efforts on obtaining advantages in the workplace for others. Because often folks don't necessarily focus on their identity issues in the union context or other contexts. So one of the things that I had noticed over many years was that the vast bulk of contracts here in Oregon that I have seen, even in mature contracts that are very comprehensive, is when it comes to civil rights protections, including civil rights protections for folks in the queer community, The standard in the contract is compliance. The language usually will read something like the employer will comply with laws for the civil rights or something like that. But that's the most common type of clause, is just a kind of like a minimum level of compliance. And although that is good, I mean, it's nice to be able to file a discrimination grievance, a lot of times the contract language itself will defer to state or local procedures. And more or less the language that we have now doesn't tend to advance members' civil rights. It tends to, kind of codify the status quo, good or bad. What we decided in our summit was that a better place for unions to think of going in collaboration with employers is to focus on best practices rather than minimum compliance, to really create procedures for both sides, for union and management working together, so that we create the most attractive workplaces for members from the LGBT community, which may very well be the candidates and employers seeking. And from the point of view of unions, we've been looking to see, how are we going? There are always conferences with unions kind of wringing their hands. How are we going to make ourselves meaningful to our younger members? And from my experience, the issue of civil rights and increasing civil rights is of great interest to members of many generations, including our youngest members. So there's a lot of reason why we want to move from just compliance to something more that enhances people's rights. And obviously in places where there are no state laws, and since the federal law is in some sort of flux, the collective bargaining agreement is a place where the union can do quite a bit to protect the rights and enhance the rights of members. So part of what we did at the summit was to brainstorm what issues were most important to the members that were there. And we worked on creating contract language, which was then sent out after the summit was over to the participants, so they could attempt to use it in their contract negotiations. So part of what we developed were a transgender bill of rights, compliance procedures when folks are exposed to microaggressions at work. We also worked on improvements over the ADA. The ADA is a very dysfunctional law. There is not a showing that it has significantly improved the well-being of folks with disabilities on the job. So, and remembering that people from the queer community live rich, multi-nuanced, intersectional existences. They may be disabled, they are folks of color, they are every other category of overlap. So we're not trying to only enhance the rights of white gay men. We're looking to especially look to the rights of the most marginalized, which at this point in time, we could probably agree is trans folks. So we also look to see on those other issues, immigration and so forth. That is in the material you can download. I won't be going over every part of it because we don't have time. Part of what I'm suggesting is really a change in mindset for both union and management to think of this as an opportunity to flesh out the ways that we can create pathways of success when LGBTQ people face any kind of roadblocks, obstacles, or low-level harassment in the workplace. My experience as a 30-year labor and employment attorney is that, in representing people of color, women, folks that come to me and say who are miserable at their jobs, often it's because of the little things, the little remarks, that the death by 1,000 cuts situation, which are microaggressions. So wanted to see if we could figure out mechanisms for fighting that as part of the contract. So when part of what the Transgender Bill of Rights does is, first of all, provide a common vocabulary. One of the things that can be difficult for people wanting to do good things and create positive policies for folks in the workplace is kind of lacking the vocabulary that is most affirming to people in the trans community. And that vocabulary does change, but the attempt to use it. So part of the trans Bill of Rights includes, educating people, what does the term non-binary mean? what does the term transgender mean? What does the term transition mean? So that people can, in other words, it's part of it is just getting on common ground with vocabulary, and then creating really good mechanisms to deal with situations like transition. Whoops, let me go back. Sometimes it will happen that a person who is trans wants to transition on the job. The language we came up with at the Queer Summit was the right to a transition plan, so that the parties could work together to make the transition process as positive as possible for the employee, as well as providing some help for the person's coworker who may not know quite what to do. So we have the idea of creating a transition plan. That includes things like allowing the person to change their name, allowing the person to change their pronouns, having the employer go back and change the names and so forth in their online records to the extent that's possible. So there are a lot of different ideas that we suggest for bargaining that may not cost a whole lot, but which if a trans employee can successfully transition at work and feel supported, that creates great loyalty, especially to the union that assists in that process and to HR who assists in that process. And that doesn't always happen in the workplace today. So being able to create this kind of a roadmap for helping people so that both management and labor knows what they can do to help folks can be a really, really great way to go beyond what parties might think that they're required to do under the law. Trying to get through all of this and still leave some time for discussion. Another thing is that there are parts of the civil rights laws that are very limiting for LGBTQ people, because some LGBTQ people, for example, queer folks of color, trans folks of color with disabilities, usually the more marginalized identity you have, the more discrimination you face, obviously. So part of what we wanted to do is add the right for employees to file claims if they face discrimination based on their intersectional identities, which I could talk about for a long time and I'm not going to. But basically adding the ability to do the things that will allow them to bring discrimination to the attention of both the union and the employer. Right now, if you have a discrimination claim under the law, let's say you are a Black woman, you can say that you're discriminated based on race, or you can say you're discriminated based on gender, but you can't combine the two and say, well, I was discriminated against as a Black woman. That intersectional analysis is not yet in our law. This would allow grievances on that nature, and allow the employer to be aware of the harassment and to put a stop to it. So I think that's, these are things, again, the idea is to retain employees who might otherwise leave due to subtle discrimination that occurs at work. The idea, again, focusing on trans folks, making sure that their identities that they're not outed with their, what we call ghost names, the names that they know, the names they were maybe assigned at birth that are not the correct gender, allowing that to be removed, lots of other things like that. Obviously, bathrooms is a big issue. We have a provision on bathrooms. We know that microaggressions occur commonly to LGBTQ folks. And they're, again, I believe, one of the main causes that people become dissatisfied with what might be an otherwise wonderful workplace. They wind up having to leave. So again, we've created a mechanism for being able to really talk about microaggressions that might occur in the workplace. And it doesn't, obviously collective bargaining agreements mostly rely on the idea of stopping harm. The biggest thing that happens usually in a grievance is that, the union is asking for whatever is happening to stop. And in this case, this would not be having a mechanism to alert the employer under the contract provides a really good way for both the union and management to work together to maintain a positive workplace environment. Trans-inclusive healthcare, pretty important issue today. Some of you may have woken up and heard that the Trump administration is now interpreting non-discrimination provisions of the Affordable Care Act to exclude transgender folks from protection. Makes it even more important that we look at trans healthcare. Some of the problems that trans folks face in obtaining healthcare is obtaining culturally competent care. Oregon and Portland especially is kind of a wonderful place because we have so many trans folks. Many trans folks move here because we have under our health plan, the Oregon Health Plan provides a very rich package of what trans folks can access who are low income, including, gender affirming surgeries. So we do have a lot of trans folks in Oregon, which gives us the opportunity to really focus on what issues are important based on lived experience. And healthcare is a big issue. A lot of times people are unable to get culturally responsive care, or they're unable to obtain culturally responsive care in a timely manner because there are not necessarily in-network providers that are the choice providers that the trans folks want to use for their surgeries. So again, part of what we do in the model language is to be affirmative about assigning an employee someone from HR who's knowledgeable about trans issues, who's trans competent, and who can help walk with the employee through the processes that they need, kind of a concierge care for trans folks who are going through the process, so they don't experience the type of obstacles they might otherwise do. Also, other general things we have in the policy are things like taking out the he and she, or the he in the contract language to make it more inclusive, creating rights to privacy and protections for queer families. So I hope that you'll have the opportunity to look at the proposals that we worked on. There were people from so many different unions and vantage points coming together to brainstorm what the needs are of people from the community. So again, this was kind of a crowdsourced set of proposals that I hope you'll enjoy looking at. I think that if they were adopted, there would be fewer people leaving workplaces because of discrimination, more loyalty to unions, and more loyalty to employers. And as Jonathan has told me, and I believe him very much, employers may be very welcoming to these sorts of proposals because employers want to keep their best workers and don't want them to face discrimination. We know that people are becoming more accepting of LGBTQ folks, but it's usually so much as they conform and assimilate to dominant culture. The less someone assimilates to dominant culture, the less protected people are, which always puts trans women of color as at the heart of the worst treatment that can possibly be given out in the workplace. So these protections should protect people who are most marginalized, all the way up through people who have more mainstream queer identities. That is the end. I wanted to share, I don't like to do anything without sharing art. And this is a wonderful cartoon by Betty Turbo. It is copyrighted to her, but I wanted to share it with you. You can't be here to share Wonderful Queer Portland with me, but I'll share the cartoon with you. So please do avail yourself of the Queer Summit model language. If you have any questions or suggestions, you can go to the Google Docs and put them in there. I hope that many unions will use this language. Usually it's better to try to adopt this type of language before you have a case of an act. A lot of people say, well, we don't have any trans people here, so we don't need any language. And when folks say things like that, I think, well, if you don't have, you probably do have trans people in a workplace of any size. What you might have is people who are too afraid to come out. And we know from the studies by psychologists and so forth, and certainly the moment we're in now, people really do need the ability to feel authentic and to bring their whole selves to work, as Bill said. So thank you very much, and we will take questions.
Thank you, Barbara. Okay, I'm just looking for all our participants. Here we are. We do have a few minutes for questions. Are there any questions for us as a group? If you can see in the chat room, I put for everyone the two emails. Should you prefer to email the questions, you can email it to the Gmail for New Jersey Lyra. We will then disperse them, or Jonathan and I will disperse them appropriately. And or if you have questions directly for Barbara, especially on her training and consultant work, email Barbara directly. We have about 3 minutes left, and I would like to pose something, because this is definitely the responsibility of both the union and the employer. Because this is about a unionized workforce. So Jonathan and Barbara, I'm going to focus on you a little more than Bill at this point. What is your opinion on beginning to initiate this type of language, especially in an employee that does not or have not had incidents of problems involving LGBTQ workers, or maybe do not have anyone at that time?
Since Barbara already mentioned me, let me just respond to what you said, Lucille, and I think what Barbara said too. First of all, as Barbara said, it shouldn't matter whether you've actually had, first of all, whether not everybody who is part of the queer community is out. We know that. I had a client who was both Black and gay, and he was in the closet, and he would put up pictures of his nephews and nieces in order to give people the impression that he had kids. So you don't know what your work, it's not like necessarily with racial minorities where everybody sees you. When it comes to LGBTQ, sometimes you don't know, plus you don't know who you're hiring. So the point is that, I think that legally and morally, we need to be on top of these issues, irrespective of what we perceive our workforce to be, and irrespective of whether it's a blue collar workforce, because I hear this when I do trainings, well, it's cops, it's this, it's that, so it's going to be different. I don't accept that for a minute. One point that I'd like to make is management is expected to do the minimum when it comes to putting out things that can make us liable. So when you read employer handbooks that come from management, frequently what you're going to read, not a bilaterally negotiated collective bargaining agreement, but an employment manual, it's going to usually have the laws that are there. But we have a different role. We're trying to tell people what laws to follow, so that way we can protect ourselves if we get sued. Our job isn't necessarily to advocate on behalf of the employees, especially when the employees have voted themselves to have a union to advocate on behalf of the employees. So at that point, I'd expect the union to be the one making these proposals. But the fact of the matter is, in New Jersey, and I can't speak about Oregon, the unions almost never make these proposals, not just about LGBTQ, but about everything. I'm always the one who comes in and says, well, the New Jersey law against discrimination is much broader than what's in the contract. Let's do that. Let's change the maternity leave provision, because that's sexist and that's not something that complies with law. So my question is, why won't the union be the one who does it more frequently? And I think it's because sometimes the union doesn't have an incentive to do it, that maybe it's a democratic organization. As management, that means that it's incumbent upon us to do it. The fear isn't having these protected categories in a state like New Jersey in the contract, because if no one files a grievance in New Jersey for a category, for being discriminated against on a category that's protected by law, you don't get attorney's fees, you don't get damages, the union has to support you. For that reason, you don't do it. So we want, from a managerial perspective, our employees to know what the rights are, and that's for everything. So that's why it's in our benefit to make those proposals if the union's not making the proposals.
Thank you. Barbara, I know you responded throughout your entire program. We are out of time. Do you have a 2 minute or a two-liner to give back?
Yes, I want to say allies, you allies that are listening.
There you go, a two-liner.
You are the people I'm counting on.
questions now posed. I am, and Barbara, I know you responded. I did respond. I think we've kind of covered them. You want to double check that before we leave? If,
I just want to finish my thought, which is that I think it's really
because we
important.
do have to end the session. There's another session coming into this breakout room. If anyone has a question that feel they weren't answered, or they have another question, please send it to one of our emails and we will accommodate that. I can't thank Bill and Jonathan and Barbara enough for all the hard work we have done. They have been amazing to work with. And I want to thank our audience for joining us today. Thank you, everyone. And we will be leaving.